Hi guys, Brendan Basiga here, Basiga Law Firm. Happy New Year first and foremost. I have been asked to do a follow-up video on the difference between operating while intoxicated versus operating while impaired. Okay, so those are two different things, folks. There's a lot of legal subtleties behind them, but I think it's probably most prudent to actually go backwards and work our way forwards. Let's start with operating while intoxicated, okay? That has many different names: DUI, drunk driving, those are some of the more common terms. That's what they mean, that's what people mean when they talk about drunk driving. That's operating while intoxicated, okay? That's the straight DUI. But the lesser known offense is known as operating while visually impaired. Now let me break that down. It essentially means that the individual is operating a motor vehicle while acting or looking like or seeming like he or she is impaired. That's either by way of drugs or alcohol. Okay. What it comes down to is that if somebody is charged or convicted of operating while visually impaired, that means that the prosecutor does not have to prove a blood alcohol content. Okay, so that whole 0.08 or 0.17 or whatever the case may be, that doesn't apply. It just means that the prosecutor has to show that this person, this individual, was operating a motor vehicle and it basically seemed like or looked like, and they were substantially impaired by either drugs or alcohol. Okay, so they don't have to show a number. They don't have to. There isn't some magical threshold. Okay. That is one of the main key differences between operating while intoxicated versus operating while impaired. Okay. In a previous video, I actually was talking to attorney Lisa Speaker, and I was saying that a lot of people are being charged with operating while visually impaired when it comes to marijuana. Everybody knows in Michigan, marijuana is now legal. That doesn't mean it's legal to drive while you're under the influence of marijuana. In fact, that's a horrible idea. Don't do it. It's okay. Take my advice. Don't do it. Because you can still be charged with operating while visually impaired, meaning they don't have to show that you have a certain THC level or a blood alcohol level. You're just intoxicated. Okay. But when I was saying about going backwards and moving forward, I guess for practical purposes, one of the main differences is the consequences. Okay, operating while intoxicated, in other words, drunk driving, you're facing up to 93 days in jail, up to 360 hours of community service, up to $500 in fines and costs. Your driver's license is going to be suspended for at least 30 days, and then restricted thereafter for another 150. Okay. Now, restricted driver's license doesn't mean you're free to drive wherever it is you want to drive to. That's essentially for school, work, religious purposes, or court appearances. That's it. I mean, otherwise, you can't drive. Now, operating while visually impaired, although it carries the same sentence as far as the jail is concerned, the fine is a little bit less. The maximum fine is $300. I'm sorry, backtracking to operating while intoxicated. You also get 6 points on your license. Okay, 6 points, which is a lot. Operating while visibly impaired, 4 points on your license, $300 in fines, up to 93 days in jail. Okay, but as far as your driver's license is restricted for 90 days. Okay, it is not necessarily suspended. Okay. However, this is where it gets a little tricky. If you are convicted of operating while visibly impaired due to marijuana or a controlled substance, in other words, drugs, it's restricted for 180 days. Okay? So it really depends on the circumstances of your case. The bottom line is this. Operating while intoxicated is the more serious offense. Operating while visibly impaired is a very close second, but slightly less penalties. Okay. The burden of proof In other words, what the prosecutor has to show is slightly less when it comes to operating while visibly impaired. When it comes to operating while intoxicated, they still need to show that your blood alcohol content was above a point, at or above 0.08. Okay? If you have any further questions, and I know this is a very confusing area of the law, please give us a call, 517-708-7830. Happy to talk to you, happy to explain this a little bit further, but this is sort of a quick tutorial and a follow-up to a previous video, as well as an answer to a request. All right, thanks guys. Happy New Year.